So the Ninth Circuit en banc panel just closed the door on any potential for a Freedom Week. The Ninth Circuit en banc panel just issued their order, which is effectively staying the Judge Benitez decision, preventing the ability to purchase or possess any new magazines that hold more than 10 rounds. We just got the order, so let's break down what they just said. But real quick before you jump into this video, if you think this California magazine ban is clearly unconstitutional, go ahead and hit that like button and subscribe. So like I mentioned in the intro, in this video, we're going to be breaking down the recent order that we just got that just dropped in the Duncan v. Bonta California magazine ban case. Recently, the Fifth Circuit en banc panel took up this case, Duncan v. Bonta, as a comeback case, and we're going to decide whether or not they would grant a stay against the Judge Benitez decision and essentially prevent the possibility of any Freedom Week. When I was recently out at Route 66, one of the common questions that popped up probably hundreds of times was what's going to happen with the Duncan case, what's going to happen with magazines on October 10th, and we just got the decision from the Ninth Circuit en banc panel. The en banc panel claimed that under their rules, they can take this case up right here and now as a comeback case and rehear it, and then also decide whether or not a stay needed to be issued on the Benitez decision. They then extended out the administrative stay until October 10th, and so the question was what was going to happen today? Well, we just got an order from the Ninth Circuit en banc panel, and shocker, they sided with the state of California once again. And really, they put together a really short and flippant answer about why they're issuing the stay in the favor of the state of California, essentially saying that they believe the state of California has a likelihood of success on the merits, even in light of Bruen, that they will suffer irreparable harm. They also said the balance of equities is in favor of the state of California, and that it's also in the public's best interest to have the stay in place. So a majority of this panel once again ruled against our right to keep and bear arms, specifically these magazines that hold more than 10 rounds. So I'm going to read to you some of the language here in the order, and then also the dissent written by Judge Bumate, because again, they are kind of sounding the alarm on how radical the Ninth Circuit is and how they do not believe in our fundamental right to keep and bear arms, even in light of what the Supreme Court just said in Bruen. So in this order, they state that California Penal Code Section 32310 subsection A creates criminal liability for any person who manufactures or causes to be manufactured, imports into the state, keeps for sale, or offers or exposes for sale, or who gives, lends, buys, or receives a large capacity magazine, which is defined as any ammunition feeding device with the capacity to accept more than 10 rounds. Plaintiffs, 5 individuals, and the California Rifle and Pistol Association filed this action in the Southern District of California, challenging the constitutionality of Section 32310 under the Second Amendment. On September 22, 2023, the District Court issued an order declaring Section 32310 unconstitutional in its entirety and enjoining California's officials from enforcing the law. On September 26th, Defendant Rob Bonta, the Attorney General of California, filed an emergency motion for a partial stay pending appeal. The Attorney General seeks to stay all portions of the order except those regarding Sections 32310 C and D, which relate to the large capacity magazines that were acquired and possessed lawfully prior to the District Court's order granting a permanent injunction. We grant the motion. So they're saying that they're granting the motion in favor of the state of California. And then they say, when deciding whether to grant a stay pending appeal, a court considers 4 factors. And so this is the factors that they're considering, similar to an injunction. Whether the stay applicant has made a strong showing that he is likely to succeed on the merits. 2, whether the applicant will be irreparably injured absent a stay. 3, whether the issuance of the stay will be substantially injure the other party's interest in the proceeding. And 4, where the public interest lies. Here, a stay is appropriate. So they are finding all those factors in favor of the state of California. So you would think looking at these similar standards, which would be similar to a preliminary injunction or something like that, that you would see a hefty analysis under Bruen looking at the text, history, and tradition of magazine bans to justify granting this type of stay. Well, that's not at all what happened. Instead, what you see is here the en banc panel cites to other kind of court decisions that have happened in other district courts in other jurisdictions that are not binding on the Ninth Circuit, and they're using that as support to justify this current stay and preventing the Judge Benitez order from going in place. They state that first, we conclude that the Attorney General is likely to succeed on the merits. In New York State Rifle and Pistol Association versus Bruen, the Supreme Court reiterated that, like most rights, the right secured by the Second Amendment is not unlimited. So here they're trying to pull some language from Bruen to say that they can justify these bans. They go on to say that notably, 10 other federal district courts have considered a Second Amendment challenge to large capacity magazine restrictions since Bruen was decided. Yet only one of those courts, the Southern District of Illinois, granted a preliminary injunction, finding that the challenge was likely to succeed on the merits. So then again, what they're doing is they're going through and saying there was all these other district court decisions upholding magazine bans. We're going to use that to justify this current stay which we are issuing. They then go also on to talk about the irreparable harm, that the state is going to be irreparably harmed. They talk about the influx of magazines, how millions of them will be purchased, and that will inherently just irreparably harm the public. And they claim, or they're buying into the California's claims, that there will be so much injury to the public and crimes will increase. Again, no heavy analysis of if that's even true. They're just essentially buying into what the state of California says. And then they say, in sum, we conclude that the stay pending appeal is warranted. So the en banc panel granted the stay in favor of the state of California. So no Freedom Week. I told you guys not to hold your breath. And we knew we were dealing with the same 11-judge panel that ruled against us prior. But then we got a couple interesting dissents, once again, from Judge Bumate. And then we also got one from R. Nelson. And in R. Nelson's, he kind of hints at what Judge Van Dyke had talked about prior, which is that the Ninth Circuit, this en banc panel, is breaking some of the rules once again, and not only their own circuit rules, but he calls into question them breaking some federal rules, and they're just breaking those rules to come to their anti-Second Amendment option that they want, which is essentially to rule against our right to keep and bear arms and have these types of magazines. But I want to focus on Judge Bumate's dissent because, again, I think he writes amazing dissents, amazing opinions, and I think he's always on the mark when it comes to these types of issues. So Judge Bumate, in his dissent, is joined by Judge Ikuda, Nelson, and Van Dyke. And again, R. Nelson also wrote his own dissent, but here's Bumate's dissent. He states that if the protection of the people's fundamental rights wasn't such a serious matter, our court's attitude towards the Second Amendment would be laughably absurd. For years, this court has shot down every Second Amendment challenge to a state regulation of firearms, effectively granting a blank check for governments to restrict firearms in any way they pleased. We got here by concocting a two-part tiers of scrutiny test, which permitted judges to interest balance away the Second Amendment guarantee. But this approach was nothing more than a judicial sleight of hand, feigning respect to the right to keep and bear arms, but never enforcing its protections. He goes on to state that several of us warned that our precedent contradicted the commands of both the Constitution and the Supreme Court. We cautioned this very panel of the need to jettison our circuit's ahistorical balancing regime and adhere to an analysis more faithful to the constitutional text and its historical understanding, but our warnings went unheard. Last year, the Supreme Court had enough of the lower court's disregard for the Second Amendment. It decisively commanded that we must no longer interest balance a fundamental right, and we must look to the Second Amendment's text, history, and tradition to assess modern firearms regulations. Now, firearms regulations may stand only after the government affirmatively proves that they are part of the historical tradition that delimits the outer bounds of the right to keep and bear arms. Despite this clear direction, our court once again swats down another Second Amendment challenge. On what grounds, he asks? Well, the majority largely does not think it's worthy of an explanation, rather than justify California's law by looking to our historical tradition as Bruen commands. The majority resorts to simply citing various non-binding district court decisions. There is no serious engagement with the Second Amendment's text, no grappling with historical analogs, no putting California to its burden of proving the constitutionality of its laws. All we get is a summary order, even after the Supreme Court directly ordered us to apply Bruen to this very case. The Constitution and Californians deserve better. And then what Judge Bumate does, which the majority did not do, is he goes through and analyzes this issue under Bruen under the correct standards. And he does this to show how ridiculous the Ninth Circuit majority is, how they did not grapple with Bruen, how they did not grapple with the Second Amendment, and how they essentially just fudged the rules, fudged this decision to come to what they wanted, which is simply to issue a stay and prevent anyone from being able to purchase magazines. Now, again, a stay was granted, so no Freedom Week. I want to make that clear. I know a lot of people are going to be asking. And where we go from here is potentially a review by the en banc panel. Now, I think some of the questions going forward from here is what happens? Maybe what would be interesting to see is maybe they're trying to signal here, maybe some of these dissents, talking about how the rules are being broken, talking about how this stay was issued flippantly, maybe trying to signal to the plaintiffs here that maybe an emergency application to the Supreme Court is warranted at this time, because you even have some of the judges on this panel talking about how rules are being broken, how the majority here is not actually doing a true Bruen analysis, how they're outright defying the Supreme Court, and maybe they're trying to signal that maybe now is the time to take an emergency application in Duncan up to the Supreme Court. Whether or not the plaintiffs here or CRPA wants to do that, that's for them to decide. but maybe that's what they're trying to signal here in the dissent from Bumate, R. Nelson, Van Dyke. Seems like maybe that's what they're hinting at. Whether or not that's a smart strategy at this time, we don't know. But as of right now, the en banc panel has stepped in. They have issued this stay in the favor of the state of California. No Freedom Week at this time. The en banc panel review is likely going to proceed forward. As we get more information, of course, I will update you guys. If you like this video and you like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos in this type of 2A news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by Armed Scholars, and this nation will be maintained by Armed Scholars.